There's AI from the moment someone calls me until trial prep and in the midst of trial, utilizing AI all along the way to be that much more effective, efficient, get a competitive advantage over the state's attorney or over other people that are in my market. It's like, I don't know other practices that are leveraging all these tools. Who's the beneficiary? My clients, the people who choose to hire my firm.
Welcome to Hot Docket, the show where we talk about winning marketing strategies that have built the most successful law firms.
Join us every 2 weeks for the latest trends and tactics to grow your law firm.
Hey, everybody, and welcome to the Hot Docket. Today we have with us, I'm not going to butcher his name because he already gave me the cheat sheet on it, David Drwencke. Criminal defense out of Chicago, the Windy City. And we have a lot of good stuff to go over today. We were just chatting prior to starting the show, and David said he's got cool AI in the works, ways to tie together systems and processes. So I don't think we've really done anything there yet on the podcast. Probably a lot of good stuff to go through.
Oh, lots of cool stuff. Excited to dive into it. And I can go on forever. I think my wife's sick of hearing me talk about it. So having an audience who actually wants to hear about it, this is refreshing.
Yeah, amazing. Let's just start at the beginning. Why don't you tell us how you got started, why you got into criminal defense, and just give us like the 1,000-foot bird's eye view.
Sure. Well, the easiest answer is it's what I always wanted to do. When I went to law school, or even before law school, I knew I wanted to be an attorney and I knew I wanted to litigate. As time went on, I clerked for a judge in Oakland County, Michigan for just shy of 7 years, and saw a million trials and was just further and further and further drawn into litigating. And criminal law was the easiest way to be in court while avoiding a lot of the stuff that I don't enjoy. I would imagine most don't, which is the paperwork and paper shuffling. Is I just wanted to be in court. I wanted to have a client who I could see and I could shake their hands and look into their face and know who I'm representing and what their interests are and what it meant to them if we were to lose. And I started my firm about 5 years ago now, and largely because I have a very supportive spouse. She saw that I was working in effectively big law, insurance defense, doing the billable hour thing. And while I was making money and I was an attorney, I wasn't having a heck of a lot of fun. And just one day she just said it. It's like, listen, you've talked about starting your own firm. You've talked about doing criminal defense for as long as I've known you. Why don't you just do it? I just kind of stood back and said, I don't know why I haven't done it. I guess I was just afraid and took the plunge in late 2020 and haven't looked back. So about 5 years or so of going live and love every moment of it.
One thing we see with criminal defense firms is, unlike, I don't know, personal injury firms who want to beat their chest every time they have a good verdict or settlement or outcome, and it's easy for them to get reviews. How do you deal with it when somebody is going through a situation that they very much don't want public, but you've gotten great outcomes for them? Like, how are you able to tell that story when a lot of people don't want that story told?
Sure. And that is one of the most difficult things is I can win a case. I mean, get the best result, go get a not guilty at trial. And you'd think in the moment, hey, can you go do a 5-star review on Google? And the client is happy to do so, but it's what do they want to include, or will they use their real name as opposed to, some other fake account or something to do the review for exactly the reasons you're talking about. It's like, we got the results you want. Do you now want to go and put it on blast that you were charged with murder or a sexual assault or domestic violence or any other number of things that you probably want to keep as private as you possibly can? And so that's part of it. Though, if anyone were to look me up or look up the firm DRD Law, and you look at some of the reviews, I have clients who do not care. Like, they put out every detail to the point where I've been brought to tears. Like, it's both funny and heartfelt. Like, I appreciate the words that they have to say about me and about the firm, but it's like, you probably didn't have to say all of this, and the fact that this is your 5th felony, among other things, save that. But I appreciate it. But you're 100% right that these are scary, serious situations, and you can get the best result, but you have to be judicious in how you share it. Have we had social media posts? Have we talked about some of the successes? Yes. Do we have to speak about it in very general terms, saying we just won a murder case, or we just won this sex assault trial. Yeah. Do we name the client? Do we get into the facts? Absolutely not. It also makes getting testimonials not impossible, because again, you'll find some folks will be willing to do it, but difficult, because to say, well, how did we help you with your drug case? How did we help you with the gun you got picked up with, or so forth? It's like, I'd rather not. I've got future employers and other people who are going to see this, so I'm not going to share it. So you're weaving a needle here a little bit in order to try to get those reviews and share success stories.
Yeah, talking about stories, one thing Andrew and I were speaking about on our earlier episode of Devil's Advocate is like what matters more, what you're saying, or the way you say it when it comes to like talking to a jury and delivering, because we were judging the two attorneys, and like without naming names, one of them was just making points in a different way than the other. Like one was kind of calmly stating facts and logic, and the other was like, I don't know, more emphatic. And we were talking about like delivery styles. What have you found to be like the most important in, if you had to rank delivery style versus like delivery content?
Well, I mean, it's an excellent question. And this is going to sound, at least at the beginning, like a lawyer answer, is that it depends. It depends on what is our argument. And there's an old adage, you've probably heard it from other attorneys, is that when you have the facts, you pound the facts. If you have the law, you pound the law. And if you have neither, you pound the table. And it depends on what argument I have. Most recently, I can give an example. It was a murder case, and where the state really leaned into theatrics. And they lined up. They went along the jury. They're right in front of them. Where the jury box, and they line up all 12 bullets, because my client had shot 12 times. He had unloaded the clip, and they just leaned into it 12 times, one shot. 12 times, second shot. They just kept going through it. It's just like, man, I get what you're trying to do. I'm following with you here, but this is a little drawn out. And unfortunately, you're not addressing the self-defense claim that is the crux of the entire case. Like, we know he shot. We, in fact, know he shot 12 times. You're not telling anyone anything they don't already accept, and that the defense isn't conceding. So where are you talking about whether or not this was self-defense? So I used that line. I was collecting my laptop, some paperwork, some of the jury instructions I wanted to address in my closing. And I said that, as I wasn't even looking at the jury. And I used that line that, pound the facts, pound the law, or you pound the table. And I just pointed over to the state. It's like, well, the state doesn't have the law or the facts, so they're leaning into theatrics and this nonsense with the bullets. Let's talk about what we actually heard during the case. Now, there are other times where, unfortunately, maybe I have to be the more theatrical one, and I'm getting into emotions, and it's like, listen, put yourself in their shoes, or whatever it may be, where the facts aren't great or the law may not be great, and I have to deliver slightly differently. I am one, especially for a jury trial. It's a little different for a bench, and it's certainly different when you're arguing emotion as opposed to a trial. That I like the theatricality. I like the delivery matters. Ironically enough, I just had a social media post where I'm talking to the people who follow me, saying evidence matters, but how you say it matters more. And you're getting into psychology. You want these people to listen, these people being the jury, to listen to you, to believe you. You're the expert in the room, your version of these facts, because more often than not, there's an awful lot of overlap. The state says it was A, B, C, D, and E, but what does it all mean? And we say, yeah, it's A, B, C, D, and E, but it means the polar opposite. So why should you listen to me? And the delivery matters. And it starts from jury selection to the opening statement of just setting the scene in how you ask questions. And then you put it all together in that closing, where I have some fun, and your voice rises and goes low. You can probably tell even right now that I'm not a monotone guy. I have fun. I smile a lot. I'm actually very happy, even when I'm getting after the police, or I'm accusing the state's attorney of a lazy case, or a rush to judgment, or whatever it may be. But I also want to focus on those facts and what it means, and that my interpretation, and whether or not the state has met their burden, that's the ultimate question. That's what you're going to go back into the jury room to decide. Not whether you like my client, you want to go grab a beer with him. Not if, all these other things the state wants you to assume, or they want you to take this one inference, which is always negative. It's like, what are all these other possibilities? And again, be believable, be the one who's in the room that it's like, yeah, he's being, he concedes what he needs to concede. He's being affable and friendly and nice. It doesn't look like they have anything to hide. And that's all psychology and delivery and done with a purpose. There's a method to the madness in everything I do during a trial.
I've got a 2-part question for you. One,
Sure.
are you part of any mastermind group that collects the data on the win rates based on like different buckets you'd put them in, like arguing the facts versus the law versus pounding the table sort of thing, to see like which one has higher or lower win rates? And are one of those for you like one that you find a little bit more difficult than the others?
I am a part of a number of masterminds for different reasons. It's for professional development. Some of it's for business purposes and learning the behind the scenes things in hiring and firing and processes and programs and software and so forth to buy. The only tracking that I can remember, and this would have been local to was a bar association, the Illinois Association of Criminal Lawyers. I'm a board member there. That we were working in conjunction with, I can't remember what college, but we were tracking some data, but it was more along the lines of what specifically in the criminal defense world we'll call the trial tax or the trial penalty, where we know what was put on the table as an offer, or what in Illinois we call them 402 conferences with the judge, where the judge says, if he or she will plead guilty or accept this responsibility, here's my sentence, if he or she will take it today or in the next court date. And then what that number is when they being the client, chooses to exercise their rights, go to trial, and then they lose. What does that number look like after trial? And trying to see what that disparity is. And it's usually, depends on the kind of case, pretty drastic, because the state hangs over people's heads weapon enhancements and so forth that they'll take off pre-trial, but at trial they're going to go for broke, and that's 15, 20, 25 years up to life for certain offenses. So we haven't gotten that in the weeds as far as tracking the numbers. I really do look at every case in its own individual capacity, because some of it is a blending. It's like, you know what, the law has a very, very specific interpretation. I know how the state is going to argue this. This is better for a bench. When the law is really on our side, I would advocate bench trial to most clients. There can be idiosyncratic things about what judge you have, of course, and so forth. But if it's a real legal argument, judge. Let's just focus on the law. We know what the facts are. Let's go there. When it is fact, weight evidence as it relates to some, maybe just testimony, it's an eyewitness. Sometimes then it's a jury. It's a grab bag because you don't know who you're going to get, of course. But that's part of the analysis. Is it's not the law. We're not getting in the weeds and something that's going to go over the average person's head. It's, can we achieve chipping away at a witness's credibility and the weight that the jury should provide to that? It's like, well, then, yeah, that's maybe a jury question, because the judge will sift through a lot of that. We'll sift through a lot of the fact that I'm nitpicking inconsistencies, whereas at a jury maybe thinks that that's really, really a big idea or a big problem for the state. And then as far as just outright pounding the table, sometimes that would have to be jury. And I can really only think of one great example off the top of my head where it's like, the law is not good. The testimonial evidence is going to be bad. The facts that are there are all bad. But there's just enough kind of craziness about what happened that I can go before a jury and say, they don't even know what's happening. They can't tell you what happened for sure. So you can't say what happened for sure, not guilty. And it was a possession of a stolen motor vehicle where had they had body camera, they did not. Had they recorded the alleged confession, they did not. They would have won the case. But we got a not guilty because there was just enough weirdness with another guy who got arrested at the same night with a different car. And it was a question of who got out of which car. One of them was stolen and one was not. And state, prove which one it was. My client says he got out of the other car, not guilty. And that was, again, based on what the testimony was going or was, and what other evidence there was. And of course, it wasn't an in the weeds law thing. It was just, this is crazy enough. State hasn't met their burden, and the jury accepted it, and we won.
David, for the second half here, I'd love to dial back and focus on AI because you at the start hinted that you're doing some pretty cool stuff with AI. And when we have the opportunity to share that knowledge, we want to. So
Sure.
um, I'd love to make no assumptions and just have you run us through high level. How is AI playing a part in your firm?
Lot of ways, both on the very front end when I have a lead and just following up with somebody who may be a potential client or they're calling on behalf of someone who may be a potential client. And that starts with the initial call. And what we're implementing right now and about to go live is tracking those phone calls, tracking those Zoom consults and so forth, and excising out everything that we can from the sentiment of the call. What were the objections during the call? If it's price or they need more time or they're comparison shopping or whatever, they don't know if we're the right one for them or whatever it may be, objections, and then follow-up items. What are some of the key points and pain points for that caller, be it if it's directly would be the client or somebody calling for that client, is we're getting as many details out of that as we can using AI. So that's on the front end, just recording a call, getting information, and then putting it together and feeding it into yet a different system that will then set out automated messages, text messages, and emails that are now going to be nuanced and specialized to that caller about what their issues were. What were those objections? How urgent was the situation? They need an attorney tomorrow, or they know their loved one isn't going to court for another month. Is it about price? What are the other concerns? They want to make sure they actually meet with me and they want an in-person visit or whatever it may be. That's all collected. And then our AI model can excise out that data, create messages that are specific to them, addressing their concerns, their issues. So it's not this rigid, everyone who calls gets the same message back. That it's just the same, hey, thanks for calling. We'd love to work with you. Get back to us if you have any questions or whatever. So the follow-up is great. Being nuanced and specific to their situation is even better. And again, that starts up with the very first phone call. So that's excising data from the call, being able to generate messages, and then feeding that through something like ChatGPT and Claude, and then using an AI chat bot as a part of my CRM tool that can address direct messages, but then generate its own messages to keep the conversation going, to address the concerns and issues that they have that are specific to that person. And I mean, to me, it's truly next level where I'm out of most of this process. We have a sales team and an intake team to do initial consultations and onboarding. I'm not there for that. I'm not the one who's then excising out the data from it. A model's doing it 24/7 and then feeding into the CRM. I'm not sending text messages and emails and follow up. The system is doing that. So no one gets lost through this process, but they also are getting a personalized journey and sales process that is to them and to what their concerns are. So that's on the front end. Some of the stuff for the practice itself is a little better known, that I use AI through. Used to be case text. Now it's Thomson Reuters purchased them. So now it's co-counsel, a part of Westlaw. But I use that for memo drafting and legal research. I routinely will use that tool in the midst of a hearing. I literally did it today where I wanted confirmation in case law that I could cite to that under the domestic violence statute, assault is enough, that because the counter argument was my client wasn't actually struck by the respondent, but was merely threatened, and that wasn't enough because there was no contact. So give me less than 5 minutes, case law, statute, something to point to and say, yes, assault counts. This is, and here's where I can point to and cite to it. And we won in part because I could do that. And the other side had no idea. Younger attorneys, perhaps not as well versed in the law to begin with, but they had nothing to counter with, and they had nothing to respond to or do the research. Beyond that, my practice management tool leverages AI in summarizing and creating chronologies of medical records, which isn't always a huge thing in criminal law, but when you deal with as many murders and attempt murders and batteries as we do, having hundreds and hundreds of pages to go through is difficult. Like, give me the bird's eye view real quick, excise out the injuries, cite to the page, and do that. AI can do that. Same with police reports and summarizing, well, what was the incident day, the arrest day? Give me a summary of what's said in there. Yes, we're going to still read it. where our eyes are going to go over this, but within moments, I have summaries and chronologies and information that I can excise out and have immediately. Huge. The last bit of it, it's somewhat new, so we're still playing around with it, but it's within the practice management tool as well, is being able to effectively talk to the case. There's data in there, again, incident date, arrest date, summaries of the arrest, summaries of from witnesses and so forth. But there's other data in there that's now been OCR'd and read by the system. I can ask it questions. It'll then pull out that document that answers the question and can provide that to me, which is awesome. That's brand new. The last bit is creating transcripts that we get 911 calls. We get what we'll abbreviate ERI, electronically recorded interviews. So this could be the victim, an eyewitness. Maybe, God forbid, my client chose to talk. Well, I get all of those videos. That's great. I have 3 hours to sit here and figure out maybe the hour they left him alone and you're clicking and dragging, making sure you don't miss anything. I can get a transcript in 15 minutes and it's in the high 90% for accuracy. Within that tool, I can also excise out, again, those key moments. And if I want to use it during a hearing or a trial, it's like, here's my client 52 times saying he didn't do it or saying no or whatever his answer was. That tool also has an AI component as far as how it gets a transcript or creates a transcript, but also being able to ask questions of it again. The example I just gave, how many times did my client deny involvement? Comes at 52 times. Here is every time he denies involvement or some other example. So there's AI from the moment someone calls me until trial prep and in the midst of trial, utilizing AI all along the way to be that much more effective, efficient, get a competitive advantage over the state's attorney or over other people that are in my market. It's like, I don't know other practices that are leveraging all these tools. Who's the beneficiary? My clients, the people who choose to hire my firm.
Yeah. So you went over a couple of like pretty interesting high level use cases, and like document interrogation, document summary, document transcription all make a ton of sense for AI. And you follow that up with like, I guess, the common mistake that some lawyers, some famously, have made, where they don't review what AI has produced, hallucinations, so on and so forth. Never a good thing. But one thing I want to touch on is, on the front side of all this, it sounds like you've got sales agents and marketing folk and people who aren't necessarily as trained in the law who might be overseeing AI processes where the AI is putting together, a message to send and it's going out maybe with, maybe without human intervention. How do you keep everyone trained who might not know the intricacies of vetting and intake to make sure that the AI is acting appropriately on those inbounds?
I mean, that is a great question. That's part of what we're building out and still testing right now. The front end component, again, excising out the data that we want, the sentiment, the urgency, the objections, and so forth, and then what messages it creates. Absolutely, somebody needs to be looking at that. And right now, that is how it's set up. It will be proposed. Here are the messages that we intend to send on a very specific cadence. 24 hours from now, 36 hours, this email, this text. They are not auto sending just yet, because we're verifying that we're comfortable with all those. And within our system, we can flag it if it was bad. Fortunately, I'm going to knock on whatever I have to knock on. We haven't had anything truly wild that's come back, mainly because we are trying to sandbox this as much as we can. It's like, this is the universe of data you can pull from. Here is the very long and specific prompt about what type of messages you're allowed to create and send. And then we're testing through that so that we don't have something inappropriate being said or giving legal analysis that it's not allowed to do. Same with the salespeople. They can answer plenty of questions. They can onboard people, make sure we're a good fit and so forth, but they can't answer legal questions. So we're making sure it doesn't do that. The other tools as well, yes, there's a concern about hallucination for sure. What I like about the tools that I have and that I use is that, first and foremost, yes, it's sandbox. It's not just going to the web and doing research and coming back. It's here is the universe of data I'm allowed to look at. And if I'm referring to AI like it is a person, I talk to it as if it's a person more often than not. It's like, here's my answer. Here's a hyperlink to where it came from. and that you can cross-reference that. Within my practice management tool, let's use the medical document example, because those are the most robust, is I'm actually looking at both. Here is the summary or the chronology. And as I'm doing that, you see the real document to the right is right there. And it's okay, it only came from this document. It's not creating its own stuff. It's showing the work, which I would say that is my favorite line for 2025 for everything we're doing, that it's data driven, but show me the work. Where in years past, it was a bit more simplistic. 2024 was just video. So I wanted to be everywhere on video. This year it's data, 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 and show me the work so that I have an understanding as to, what direction we're going to go and whether something is good or bad.
Because you're measuring everything in your intake and practice management software, what sort of numbers can you give us in terms of you onboarded those unique messages that are using AI to what you had prior? Did you see a lift in the conversion rate of like the leads that have qualified as opportunities that you would have wanted to sign? What did onboarding that do to your conversion rate?
I have seen an uptick, and part of part of this, they went side to side, or at the same time, they were in parallel. It would have been great to really create an A/B test here between just having the system and then hiring the intake team. The intake team's relatively 6 weeks in at this point. Previous to that, it was me. Like many people are probably listening to this podcast or people starting their own law firm. I started with a pen and paper that worked up to a Word document, that worked up to an Excel spreadsheet, that worked up to what's a CRM, and then, other tools where, again, yes, it's tracking it. It's great, but I'm still sending the text. I'm still sending the email. Now you find, this system will automate things. You have to pre-write everything. Super rigid would be the word that I'm using. It's not personalized. Maybe, yes, it starts with the person, Dear John, thanks for reaching out to the firm. But now it's that much more nuanced. I am seeing an uptick. I attribute a good portion of it to the new system. The other part is I'm also attributing it to an excellent salesperson who's available all the time. Where I'm in court, I'm in and out of hearings, I'm on the other line, I'm doing a consult, I'm talking to a current client. There are calls that fell through, and then I needed to follow back up with myself. That is not a problem any longer because I have a dedicated salesperson. That is their job. Pick up the phone, answer questions, follow up with people. So that is some part of this, some percentage. It's tough to say exactly how much. But the other part is, and because I've seen it, I've heard it, is prospective clients or their family members are so happy that we didn't give up on them, that they got cold feet. It's a lot of money. They don't know what they don't know. They're not sure what direction to go in. And they get cold feet and they freeze, or they're not sure, that they're thinking of what I do as a commodity. And it's like, well, I could find anybody who's a criminal defense attorney that this defense attorney gets this result. And it's like, well, that is not true. Really good attorneys at whatever the specialty, mine's criminal, can do something different. And people then start to realize that too. It's like, man, thank you for following up. And sometimes it's a month later, like, thank you for emailing me. He was just in court. This is like a family member or mom or dad. Our son was just in court yesterday and your email came up. We're really mad at the private attorney that we hired, or we're not satisfied with the public defender. So it's a confluence of things. So there's no one silver bullet, but it's that mixture of things. It's having a salesperson that's available. It's having automated messages so that you're a part of the process with them over a long period of time. But now with the nuanced messages, they feel like this, hey, this is for me. This is to me. This is addressing my problem. Or my son's problem or daughter's problem. But I feel like you know me and you're addressing my problems in a way that you'd have to have 100 people working in order to do that and have copious notes, and they're referring to the Rolodex and doing it on their own. Well, now I'm doing it with one salesperson and some AI tools that can do the work of dozens of people probably.
Do you have a rough sense of how many messages and how many touch points there are prior to the client signing the retainer?
Ooh. I know what is in our automated system that will go over the course of a month. So we're talking between text messages, emails, voicemails that'll be left, voice messages, because our tool can send iMessages as well. So I can send GIFs and photos, and I can send voicemail or voice messages, be more specific, not just voicemail. Another AI, because I'm thinking of it right now, part of that is I can personalize voice messages to clients based on AI because I've trained a voice model of myself. So it was me reading for a few hours to the system, and little uncanny valley with it. I could probably tell the difference between real David and voice David, but all these tools are there. So they being prospective clients, no matter where they're at, they're being contacted in a way. So whatever is best for them. If it's email, great, that's there. If it's text or iMessage, that's great. It's a voice mail. It's a voice message. It's sending links to YouTube videos about the brand, the firm, about the firm in general, like our brand overview, information about pricing and payment plans. If we know it's about a specific type of case, I have long form videos on YouTube where it's like, oh, hey, your loved one or you're charged with a gun offense. Here's an analysis of what actual and constructive possession is in Illinois. Here you go. And you can just embed this stuff and they get it. And they get information. They get a feel for my personality. And that's the experience I want them to come away with on the front end. It's like, wow, nobody else is doing this. Nobody's doing it to this level where I'm getting this personal attention and everything feels like it's geared towards me and my problem. And that's where I've seen a further uptick. Every new little system about following up improved things, from that pen and paper to Excel to having a CRM, but now having something this fully featured and this sophisticated, it just cranks it up that much more.
David, thanks so much for walking us through your processes. I want to be cognizant of the time here because I know we're definitely running a little long, but you shared a ton of great information with us, so I think people are going to get a lot of value. As we wrap up here, is there anything you'd like our listeners to know or check out? Any I don't know, anything new
some
going
plugs? They're always busy, always running around in court. I do have a podcast. It's Defending the Windy City. It comes out monthly talking about criminal defense issues in Illinois. There's a Chicago focus there for sure. But if you want to learn more, or if there are attorneys that are listening, curious about all these different tools, Open Door Policy. I can, as you can probably tell, talk about this forever. I love it. So I appreciate the opportunity.
Amazing. Well, thanks for joining us. And I learned a lot. I'm sure everyone else did. We'll see you on the next Hot Docket. We hope you've enjoyed this episode of Hot Docket. We're your hosts, Bobby and Andrew, founders of MeanPug, the marketing agency for ambitious law firms.
Have questions about marketing or anything we covered today? Email us at mark@meanpug.com.